We're tackling all the headlines today here on the Business Immigration Benchmark, site visits, compliance, and what to expect in 2025. And here to help us tackle those thorny issues is the W&WR's managing partner, Bernie Wolfsdorf. Bernie, welcome to the Business Immigration Benchmark.
Laura, thank you so much. It's really a pleasure to be here with you. I wish the topic were a little less stressful, but the bottom line is we've got to address it. We've got to be ready. So looking forward to it. Thank you.
Exactly. So that's what we're going to be chatting about today. And, our listeners and what we're uncovering in this Q1 benchmarking survey is that global mobility leaders are really concerned about compliance. And of course, compliance is tested when there is some sort of investigation. So, Bernie, can you tell us a little bit about what to expect or how to even think about inspections or who comes to the office? Like what kind of immigration officer steps into an employment work site?
So, Laura, you've started at the beginning, which is always the correct place. I'm going to start off by saying, an ounce of prevention is worth a pound of cure. Somewhat of an old-fashioned statement, but it absolutely applies to this situation. We do have different types of worksite notifications. Some of them will be FDNS, fraud detection and national security contractors, or USCIS agents. But the truth is, the government is using a whole slew of new agents to focus on audits and raids. So we've got to be ready for that person's going to flash a badge, and that's going to happen at the front desk, and that's going to be somewhat of an emotional event. And you've got to simply be ready. You've got to understand and have the internal protocol in place so the reception or the front desk person knows what to do.
Yeah, no, I think that's right. And so kind of bite size, because this can be really overwhelming. I've had a few clients in the last month reach out to advise on internal protocol. And so what would you recommend, from a bite size first step where global mobility HR leaders should start with developing that internal protocol?
So the number one thing which I was touching on is making sure that your front desk people understand who to call. And that's going to be either or both internal general counsel, if you have one, senior management in place, an appropriate appointed person. I tell all my clients, hey, here's my mobile number, call me. Have
Sure.
them call me directly. But the truth is, you need both. You want to have them notify general counsel and also outside legal counsel. My focus is really cooperation. So, offer them tea, offer them coffee, be polite.
That's really good. I don't know that that's always coming across. I think in our prep call we talked a little bit about, cooperation and then, just the protocol shouldn't be really elaborate. Like we don't want the front office staff having to review warrants or really get into the details. We want their first action to just be call the right person if that's the general counsel, if that's immigration partnership. That's what you want them to be able to do immediately, quickly, and then cooperatively to do that. That's their instructions, right? Like that we don't want to have a big flow chart that's difficult for them to understand or hard to navigate.
I was thinking about that situation where an ICE officer appears at the company's front desk, and what do we advise? So there are certain different situations. Let's deal with the situation where ICE comes in and they want to check your I-9s. There are 2 or 3 ways they can do this. One way is they may give you a notice of intention to inspect. Under the notice of intention to inspect, you ordinarily have 3 days to produce your I-9s, although in the past ICE has been quite reasonable in terms of granting extensions because, I mean, you may have hundreds of them, thousands of them. You can't really produce those in 3 days generally. So they're kind of flexible. That's your I-9 audit scenario. Then there's the ICE raid, pick him up scenario. That one is obviously more scary. You have an officer appearing in a uniform with a gun, maybe more than one officer, and they will potentially show what they're going to call an ICE subpoena. That is now getting complicated. The advice that I will generally give to front desk and for front desk training is the front desk personnel are not qualified or equipped to evaluate subpoenas. The ICE subpoena may not be a legal subpoena. And at this point, the advice I give is that the front desk needs to be trained. And they should always be polite, of course, and mention to the officer, well, sir, well, ma'am, I'm so sorry, but I am not authorized to admit people, if this is true, of course. I'm not authorized to admit you. Please take a seat. Would you like some tea or coffee? Always be friendly, but I have to check with the company's general counsel or CEO, C-suite, or if we are your counsel, we have to check with outside counsel. That is the general procedure. If the front desk authorizes the officer to enter the premises, any rights under the Fourth Amendment are effectively waived, and the officers can proceed based on that front desk consent. So this is a complex issue. It does require training. We're not going to do an analysis of the different types of subpoenas today, but generally speaking, unless the subpoena is issued by a court and a judge authorizing entry and search based on reasonable evidence, the subpoenas that might be presented could well just be sort of a trick to get consent. So I hope that's helpful. And of course, they need to have those mobile numbers on call.
Right, and that, if anything, when you're reviewing your internal protocol, maybe you already have this, but make sure that the numbers are updated and can reach an actual person as instructed. So, this is a little bit off script, but what are the flavors of investigations that an employer may encounter this year or in future years under a Trump administration?
So I think I would break this down into three different categories. Um, Firstly, in terms of your I-9, which is the employment verification forms, that can come in two forms, two sizes. Number one, the so-called desktop raids, which, those aren't as scary on the face. The administration previously sent out 5,000 of those, and quite frankly, those are still in the pipeline, and then another 5,000. Extremely effective, extremely broad. So you've got your I-9 notifications. There is, of course, also the canine version of that, where ICE will come in and do a raid. They'll block off the front and the back of the business, and that might be when they're looking for a particular undocumented. They have knowledge on the inside that they are undocumented workers, and they're coming to pick them up. So that is extremely scary. So those are the two types of I-9 employment verification rates. Then you've got what I'm going to call your basic audits, which fall in two categories. The audit of your non-immigrant visas, your H-1B public access files, which, by the way, if you receive notice from anyone to inspect the public access file, you have 24 hours to present them. That's not a lot of time. So a key focus is get your I-9s in order, get your public access files in order. And the third one, which people sort of tend to forget about, is the perm files, because those are subject to audit within 5 years of the perm filing. So you've got to be ready on all your immigration fronts. Again, I-9s, H-1Bs, perms. And for your I-9s, by the way, some of the things you may want to look at are job site location, number one. And number two, making sure that the content of the H-1B is accurate. The person's had a promotion. They're going to want to make sure that the information in your H-1B petition is accurate. And we're going to see a lot of H-1B, FDNS site visits, and also L-1s, by the way. It's not only limited to H-1B, it's a whole variety of non-immigrant visas. Is the foreign national working in the location where you said they would be? Because location is extremely important in determining prevailing wages. And while we're on the topic of prevailing wages, are the prevailing wage, or is the prevailing wage information in the file accurate? And can you, in fact, substantiate that that is the prevailing wage, the higher of the so-called prevailing wage, or for similarly situated workers?
Okay, you said a lot. I wanna break down a few things. The first thing that I wanna dive into is, the FDNS, the Fraud Detection National Security Officers. We were seeing these types of office visits under previous administrations, and you mentioned we might see more. Are we seeing more already? Like, do you have clients that are already getting these types of compliance check visits?
Well, it's happening at various different levels. The FDNS site visits have been ongoing um, for years and years right now, but there is no question in my mind that we're going to see increased scrutiny. Let me give you an example. You know, KCC, the Department of State, Kentucky Consular Center. We're seeing, for example, a lot of inquiries from the KCC in regards to the work um, that the individual is performing, checking the factual accuracy of the petitions. So, what people don't sort of fully understand is when you file an H1 or an L1 or an O1, almost any non-immigrant visa, um, that file also goes to the Kentucky Consular Center, where it is being reviewed for fraud and accuracy, and they will reach out to the employer. This is an email. It's relatively simple, but if that email is ignored, then you might well see that as a trigger for an
It's a good
FDNS.
point.
FDNS is getting information from a variety. So the FDNS directorate falls under USCIS. Fraud detection and national security. Honestly, it's like 99% fraud detection and 1% national security. So it's not, it sounds like, oh gosh, they're going to keep us safe from these dangerous H-1B, L-1 workers, but they're really looking for fraud. And fraud, it's a broad term, but it's really a misrepresentation. Is something in that petition not accurate? So, please make sure, and this is to employers, to lawyers, make sure that the content of your petitions are factually correct and based on reality, not some formula which, quite frankly, doesn't connect with reality.
That's a good point. I have clients where this is coming up when the employee is going to go for visa stamping and they ask for a copy of their petition. Maybe they haven't looked at it, or never looked at it, and, then they pull it up and they say, "Oh, I'm not doing this job anymore," and, that's a trigger for an amendment, or they take a look at the job description, and then they say, "Oh, that's not really what I'm doing," and there can be a disconnect between if you are pulling a job description, like the global mobility function, maybe asking for the job description from HR, and maybe HR is pulling it from a job bank that hasn't been updated, but they pull it, and, that is what council uses for the H-1B petition, and then months or a year later, the Foreign National takes a look at it, and it was like, "Oh, this has never been my position." So there's sort of a data flow issue there. Again, this is pretty rare, but, you just wanna make sure that when you are collecting the job descriptions as a global mobility leader that there's verification. I even have some companies that, work directly with the manager to verify the job descriptions so that the person who in theory might even be called into a boardroom with an FDNS officer, so the manager would be able to, describe what they provided for the petition so there's consistency. And I think that's what Bernie's getting at here that, it's not necessarily like the fraud that they're finding, it's often this inconsistency between the different arms of the business that they're not all talking to each other. And then when questioned, someone might say something about the sponsored foreign nationals job that might be different from what's represented in the petition, and that's going to be super problematic. So just make sure, from just a best practice that all the information is accurate and that there's some way that internally you're able to audit in the coming months of, do the underlying petitions accurately represent the jobs that the employees are doing.
So, Laura, I want to challenge you. You said
I'm
it's
supposed to answer you the questions.
I know, but I relatively speaking, um, you file your petition with USCIS, and that officer who adjudicates the case is going to verify it from numerous different sources as to
Sure.
its factual accuracy. They have their own databases where they're going to check the company, check the position. I mean, you've got LinkedIn, everything's out there right now. So that's point number one. Point number two, I mentioned the KCC, where the petition goes off and is again reviewed by a fraud officer. Point number three, the individual is now at a consulate applying for a visa, and the officer is going to look at the petition, question the foreign national, and verify that the facts are accurate. Point number four, the individual is now entering through Customs and Border Inspection, CBP, another layer. And the first question they're going to ask is, what do you do?
Right.
And it better be consistent. And then the fifth one is these random or relatively random site visits with virtually no notice. They don't say, hey, we're coming on X date. They might call you on the way if you're lucky, but more likely they're just going to appear at your front desk, which circles back to our original point. So we are seeing multiple layers of checking by numerous different agencies. FDNS, which is part of USCIS. You've got US Department of Labor. They have jurisdiction on the H-1Bs, on the perms, to do site inspections. The issue that they are really focused on more is the prevailing wage, and they're going to want to see employment, payroll information, which they're entitled to. You have to keep that for up to 3 years. For H-1Bs, you need to keep the public access file for at least 1 year from the point of termination or end of the assignment. So there are very strict rules, and the question is, where are your H-1B files? So, having a sophisticated immigrant management system is absolutely critical.
Yeah, these are good points. I really liked how you identified the multiple areas where compliance is tested. And it's not just at these site visits where an immigration officer shows up, that there's way more frequency of compliance being tested through the foreign nationals travel. And that's where I'm seeing it, most recently, and where we're advising a lot of clients about amendments because we're identifying a discrepancy or an inconsistency in the foreign nationals job description and what's on the underlying petition. So be mindful that there are multiple other ways in which your compliance can be tested. The other thing that Bernie briefly touched on was, public access files and how these are also complaint driven. And so one case I know that, Bernie's working on that he can maybe talk a little bit about is, when there is a complaint about or just a request rather to see public access files, what's the requirement on that employer to present and how quickly do they have to present the public access files? So Bernie, can you tell us a little bit about this? This is a different flavor of audit and compliance testing where it's not necessarily an immigration officer showing up requesting, but it might be complaint driven or a public request.
Yeah, a lot of people um, think, well, the H-1B filing, basically submit to the Department of Labor the labor condition attestation. Employers, you need to read that LCA. You need to understand what it is you are certifying to. Sometimes people are using what I call DIY, do it yourself packages, and they fill out this form and they file it and they verify they've done all this compliance. And then lo and behold, you can't even find the public access file.
Right.
Whereas the rules require that you produce that public access file within 24 hours. And that is a very short fuse. So imagine the situation where you have hundreds of H-1B workers, and you've had hundreds of H-1B workers over many years. And the question then is, where are these public access files? Are they ready? And the bottom line slogan that I'm using is get your public access files in order, get your I-9s in order, make sure your perm files are up to date, because quite frankly, we've been down this road before, but we're going to see it. And for most of our clients, I'm actually going to go with 99% of our clients, it was a non-event. But I get these calls from panicked HR where, oh gosh, their lawyer didn't help them prepare. Oh my gosh, we used this outside non-legal service to do the H-1B or the L-1 and we got the approval. And okay, great. Is it based on fact? Is it based on, and where are the documents? And we haven't really got into this, but I'm strongly recommending that employers conduct internal audits now. I used the line, an ounce of prevention is worth a pound of cure. I know it's an old-fashioned one, but the fact of the matter is that you have an opportunity now to make sure that your public access files are in order. And the government is, in my experience in the past, quite flexible when you act in good faith, when you show cooperation. But oh gosh, don't backdate. Don't try and do funny business by putting stuff in that's done afterwards. You make a memo to file. If you discover inaccuracies, you update it. You do full disclosure. No funny business here. And particularly in the context of I-9s. I'll tell you a little story about I-9 inspections. So in my youth, this happened, so quite a while ago. The I-9 officer came to the HR and said, well, where are your I-9s? This is a small company. And the employer's like, I-9s? What's that? And I know it's kind of weird, but there are still people who respond with that, usually smaller companies. What's an I-9? And the officer gave them the form I-9 and said, it's this form. I'll be back in 2 weeks and I want to come and see your I-9s. Person came back in 2 weeks. They got a big package of I-9s and they were all backdated.
Oh
And that
no.
form had a little X in the top right-hand corner. It was photocopied and then backdated. Employer, you're going to prison. That
You
is a
do that.
crime. Can you believe it? So don't think these guys are dumb. These guys know what they're doing. These are enforcement guys. ICE loves to, and I don't want to scare everybody, but they'll send somebody in with a wire. They may send an employee in with a wire. to meet with HR. So everything you say has to be accurate, be conservative, and be factual based. If you don't have the public access file, don't go and try and backdate it. If you don't have the I-9, there's a framework to correct.
And the reality is anyone who has I-9s or some volume of I-9s or, any volume of an employee population is likely gonna have some errors on the I-9s. It's a difficult form. There's been so many changes. And so if you're conducting an internal audit, which we've recommended and continue to recommend that you should be doing, you're probably most likely going to discover some issues with how the form was completed, whether something was signed on the wrong line or the date. I've seen this, for, an I-94 is put in the wrong line. Like, it's confusing documents, and often your onboarding specialists aren't that familiar with H-1B or foreign national employees, and so there's the information's gonna be there, but it might be in the wrong place, and so when you're discovering these errors, hopefully you're working with counsel to coach you through how to correct them, how to correct them in good faith, how to do so accurately, so that when you're facing any kind of I-9 audit that you've addressed the issues compliantly, because most of the companies that we've seen or have helped with audits, no one bats 1,000 on this, and, it's okay as long as you're addressing, like Bernie said, the issues timely and in good faith.
Some of our clients have thousands of I-9s, and it's easy to say go and do an internal audit, but do an internal audit of hundreds or thousands of I-9s, that's days and days of work. And, if you've got artificial intelligence, you've got tools that will help you do this. You know, HR is usually very busy. It's not like they're sitting around with nothing to do.
Right,
And now they suddenly have these tasks. So there are tools that we can use and are using to effectively ameliorate what has been quite a difficult situation, because you have heavy enforcement and then nothing. Heavy
right,
enforcement. So employers tend to get slack and not as observant, but this is not the time to be relaxed about it. Unfortunately, and let's put this in a broad context. Why do foreign nationals come to the United States? Yeah, well, here in Southern California, I could say it's the weather, but the reality is people come for jobs. They come for careers. They want to live the American dream. So, putting this pressure on employers is the single most effective way to regulate immigration to the US. So if people want to understand the big picture, the question is, large numbers of people have been coming into the US. We won't get into the politics of this, but the simple bottom line is you, the employer, have an obligation to comply, and this is the time to get your I-9s in order, get your public access files in order.
yeah, it's like housekeeping. So I think, some of the other times I'm seeing issues pop up or when the maintenance of the public access files goes lax is often when there's a turnover in the internal team. And so there's just a lack of understanding of how the files were maintained. And so if you're coming into a position and your predecessor has left, this is a great opportunity to sort of review and work with counsel on a project basis to, clean up whatever the previous files, how they were maintained, and create reports so that it can be easily and effectively maintained going forward. So it can feel really overwhelming to sort of hear this conversation and say, wow, I've got a lot of compliance objectives ahead of me, but breaking it down, working with counsel, creating the data flow to get the reports so that you can then maintain things in the future. I think it's all doable. I just break it down into bite-sized pieces, working with your counsel to support the management of the audit and the management of the maintenance on a go forward.
And just basic things like, let's take the purging rules.
Sure.
Um, once you've got an audit notice, you are not purging.
Right. Good point.
That starts to get into the role of, are you in the area of obstruction? So no purging after you've got a notice to inspect. At that point, it's too late. So it is extremely important to make sure you do this on a preemptive basis before the fire starts, before the audit notice goes in, and get everything in order. And as I've said, using technology just makes life a lot more simple. You'd mentioned having reports, having the data. A few basic tips. One is, for example, do not mix the personnel file with the I-9 file. Keep the personnel file separate from the H-1B file, the green card file, the I-9 file. I-9s have to be segregated in terms of current employees, termed employees, and onboarding employees. So they've got to be clearly broken down. You have to have a system, or quite frankly, it's going to be chaotic.
Yeah, that is good advice. So, transitioning a little bit to expectations in 2025, in terms of what to expect in the year ahead, are increased site visits and additional scrutiny going to continue for the next few years? Like, what do you think?
Well, look, I think that while one can never predict exactly, we can be pretty sure that this administration is focused on immigration enforcement. The whole concept that the new administration is focused on is consequences. Consequences if you enter without a visa, consequences if you work without permission. They want to make sure that the system works and that people break the rules face consequences. So, who are the people who are potentially vulnerable? Well, there are millions of people in the United States, very often critical workers in vulnerable statuses. For example, temporary protected status. The administration just terminated temporary protected status for Venezuelans, for example. There's 350,000 Venezuelans in the US. What do you do as the employer in regard to that key employee? And the good news is there are things you can do. For the more sophisticated positions, the H-1B lottery opens March 7th. So for those people who are potentially eligible, they can convert from TPS status to H-1B status. So examine your workforce, particularly looking for vulnerable populations, the DACA kids, over 500,000 DACA kids who literally grew up in America and are in every kind of position that you can imagine. So now is the time to see, are there ways to convert these folks to other legal statuses? Could be an H-1B, could be an O-1 if they're an extraordinary ability. So there are a variety of non-immigrant visas and immigrant visa options that employers need to look at to see to what degree they can help their workforce obtain legal status, which will obviate the need for anxiety if you get a notice of intention to inspect and or the government terminates the employment authorization of these vulnerable classes. You've got TPS, asylum pending, people in removal proceedings. Quite frankly, this is millions of workers.
Yeah, I'm seeing this year a tremendous push from my clients to register these vulnerable populations in the H-1B lottery. So, I think you have to be very careful with the analysis of whether someone can change status into H-1B, but at this point, entering them in the lottery is a very good step, and working with counsel, and they might have even independent counsel that help them secure DACA or help them secure the TPS. But I'm seeing my clients make a really big push to support their employees in the H-1B cap lottery to see if they can get them in a more stabilized status with winning the H-1B lottery. So I think, the readout is, will we see higher numbers in H-1B lottery given how employers are looking to support these employees because they are valued, they're in professional positions. The employers want to retain the talent at their company and are doing so by any way possible.
I'm actually going to be optimistic, Laura. I think that the H-1B lottery um, has had pretty tough statistics the last year or two, but In my opinion, that's because certain employers have been gaming the system.
Okay.
So different employers filing multiple petitions for the same foreign national, that's out. Under the new modernization regulations, it is now employee based. And I think a lot of employers are going to be scared to do funny business. I'm predicting that with master's degree candidates, we're probably going to have over 50% and as high as 40% on the bachelor's degree category, but I'm the eternal optimist. So,
I'd love to
yeah.
see it. I'd love to see it, Bernie. We'll have you back and we'll reconfirm those numbers. The HMB lottery season, the registration opens March 7th and closes March 24th. So we'll have more readouts on that in the months to come. Bernie, what strategies can global mobility teams implement to manage continued delays in green card processing? Got anything to say about that?
Well, that is a tough one because the truth is that other than in the employment based first preference, the extraordinary ability, the senior managers, the waiting lines are quite long. Um, I'm actually strangely and optimistically hoping that Congress will finally look. We're going to get immigration reform this year. It's been 34 years since Congress has enacted a comprehensive immigration bill. Now, they keep talking about, well, we have to do enforcement first. I get that. They want to clean up the situation, but I believe that in regard to the best and the brightest, that Congress recognizes, look, almost 70% of our STEM graduates are foreign nationals. So you're looking at a large number of highly sophisticated individuals that would be critical to the workforce. And then, let's talk about unskilled labor. The reality is that foreign nationals are critical in unskilled labor. I'm talking about farm workers, warehousing, a lot of work that, hotels, restaurants, that quite frankly, these jobs, it's not been possible to fill with US workers. Unfortunately, my kids simply don't want to clean up their own rooms, never mind your room. So the reality is that foreign workers are critical at both the best and brightest level, for global companies moving their key people around, bringing in managers, bringing in specialized knowledge employees is critical. So there is a system. Um, it's been good for the economy. Look, the reality is the economy has continued to grow, and if we want to see this moving forward, we have to be able to bring in and keep the top U.S. graduates who are U.S. trained, U.S. educated, and have incredibly good talents. I mean, sorry if I'm going off the rails here, but even from a national security point of view, do we train and educate the best of the best in artificial intelligence and then send them back abroad to compete? Or do we keep them here? We're going to pin a green card on those top level PhD graduates. And, you might well see the president making um, a bold move in terms of reforming the system because it's been 34 years since the waiting line and the quotas have been adjusted. And quite frankly, the system is broken. It needs to be fixed. And I'm going to be a little bit optimistic that while the initial phase is enforcement to clean up the situation, that there will be a second phase where the government looks at ways to improve our broken system, recognizing the critical nature of immigrants at certain levels of our economy. And we heard Elon Musk talking, I can't repeat his exact phrase, but talking in a very positive way about the H-1B program. And that shows the level of knowledge and intelligence because he understands being an engineer, how important it is um, for the advancement of science and technology. So I think there's some smart people up there who are going to make the right decision, but I'm the eternal optimist, Laura. So the truth is, I don't know.
Well, thanks for sharing that optimism for 2025. I hear that, right now we're in the phase for enforcement. And so, the conversation, of course, for employers and our clients and our global mobility leaders is to ensure the company's maintaining compliance and the foreign national is maintaining compliance to make sure they can remain work authorized and travel in and out of the US. And that I love to hear and would love to see the improvement of how visas are issued, how green cards are processed, because it's been painful for our clients. The lines are quite long, and that, what we're recently wrestling with is some restrictions in the adjudication policy for EB2 national interest waiver. We saw the green era of national interest waiver in the last 2 years, and that's really slowing down. We're seeing more and more requests for evidence, more and more denials just across the board. And so, the national interest waiver was used for a lot of these very talented AI engineers, machine learning engineers, and we're seeing that slow down, or the availability of the NIW for those folks kind of close. And so the idea that the administration would acknowledge the talent that is here and is being educated in the US and offer them a way to meaningfully stay in the US with stability like a green card would be a game changer. Thanks for sharing your time and expertise. Any concluding thoughts you'd like to leave us here with at the Business Immigration Benchmark, Bernie?
I'm again just this eternal optimist that the economy is going to drive the immigration
Right.
policy. And while at the present time we're seeing some anxiety from employers, for example, we have a very large outbound immigration department at WR, and they're busier than ever. So some employers are looking at potentially transferring certain key workers abroad to their overseas facilities. We're seeing quite a lot of Americans being moved to places offshore. That is a surge that we are seeing. But I'm going to say, yeah, look, even with the NIWs, it's true that the standard is getting slightly more rigorous, but the good cases are still getting approved. I just
That's
got an
fair.
EB1 approved last week, which I was anxious about. Um, but USCIS approved it in, 2 weeks, so we are getting approvals on our EB1s. The NIWs are definitely more difficult, but our O1s are getting approved, the H1Bs are getting approved. I think, what we just have to make sure is that, that these are compliant cases, that these
Right.
people do meet eligibility. There's a lot of anxiety out of there, and I think our role as immigration counsel is to just assure both employers and anxious employees that if we follow the rules, if we follow the regulations, things are going to be okay. If we break the rules and you want to drive, at 100 miles an hour over the speed limit, yeah, you're going to have problems. So this is the time to um, get your documents in order, focus on your immigration, and my prediction is that we might see some pleasant surprises, but I'm the eternal Pollyanna optimist that they're going to do the right thing. We are a nation of immigrants. So I'm optimistic that the economic forces and the forces of reason will prevail.
Well, Bernie, thanks so much for coming on and sharing your time, talent, and optimism with our listeners. Really appreciate you here on the Business Immigration Benchmark. We'll catch you next time.
Thank you so much.